on the matter of goods and the Commissioners for His Majesty's Revenue and Customs.
Yes.
My lady, in this matter, I appear for the appellant and Ms Nathan appears for the revenue. I hope you should have received, in one form or another, a core bundle,
Yes.
2 supplemental bundles and 2 authorities bundles.
We have indeed, and I think, well, I'm confident that we've all had an opportunity of reading all the core material, including, in particular, the 2 most significant authorities, or 2 authorities which you've both highlighted most.
Thank you. Yes, so you'll have seen this. This is an appeal from the decision of the upper tribunal, constituted by Mr Justice Green and Judge Thomas Scott. And there was a case of somewhat unfortunate timing in the way that the cases were progressing through the courts at the time we were considering this matter on 2 of the main issues in the case. One was discovery, and at that time the Supreme Court had considered the case a tooth, and that collapsed the discovery arguments in this case. And also, at the same time as we were hearing this in the upper tribunal, the Court of Appeal had just heard the decision in the Khan case, which really was a central issue in the present case, and we dealt with it by way of written submissions after the upper tribunal heard it. So certainly the focus of my submissions this morning will be on the Khan case.
Yeah, I rather anticipated that was the case. I saw the juxtaposition of dates when I was doing my pre-reading.
Exactly. So what I would hope to do is take you just to the scheme and the documents,
Yep.
and the First-tier Tribunal's summary, so that we have an understanding of the context. Then go to the Khan case, principally.
Yes.
And then take you to the upper tribunal, because although we all agree that the Khan case is the last word on this and the leading authority, but there is a difference between the parties as how you interpret it.
Yes.
And then, after going to Khan, take you to the upper tribunal to explain where we say the upper tribunal has misapplied the principles in Khan. And then, at the end, sort of pick up any sort of satellite cases that are relied on by the revenue, which may be relevant. So that's the sort of the format today.
Excellent. Thank you very much. It's most helpful.
You may have looked at the scheme and its summary in various places. There's a helpful overview of the scheme. This isn't a case where one needs to have an absolute understanding of every single element of it, but it is a case where it's important for you to understand the substance of the scheme and what it was really about. And there's no real disagreement on this. There's no real disagreement on the underlying facts, as there wasn't before the First-tier Tribunal. But in the First-tier Tribunal does set out a helpful overview in its decision, which is tab 10 of the core bundle. Pages 134 to the next few pages after 134. So I won't read those out, but that is, in my submission, helpful submission from paragraphs 13 to 25 of just the overview, and then it is worth looking at Mr. Good's the particular facts that were relevant to Mr. Good, the appellant, which are 28 to 32. But I hope you would have seen anyway that the idea of the scheme was to set up a structure in which individual investors would enter into and thereby be carrying on a trade for tax purposes, a sole trade of exploiting film rights. And it was important to have a trade because that was the means by which the individuals would be able to access the special reliefs that applied to trades, and they could therefore set the loss that was intended to be made in the first year of this trade against their other income, and that was that is why this concept of the trade was critical to the scheme working. And exploiting film rights by acquiring and distributing them is certainly a recognised trading activity. But the individuals who were to carry out this trade were just ordinary members of the public, unlikely to have any personal experience of negotiating film contracts or distribution contracts. And so the promoters of this scheme, the Scion group, set up a self-contained contractual package under which one Scion entity called Scion Rights Limited would acquire film rights from a real studio, and then the Scion entity would sell those rights to the sole trader, who would immediately sell them on, assign them on to another Scion entity, that is Scion Distribution Limited. So the individual was just slotted in to a sort of contractual chain with one Scion entity on one side, the other Scion entity on the other side, and then the real world outside that. So the individuals didn't need to negotiate any contracts themselves. They didn't sign the principal contracts. A Scion entity was appointed as their power of attorney, and the power of attorney signed up for Mr. Good, the acquisition agreement and the distribution agreement. And that activity it was hoped that entering into that acquisition agreement and then the distribution agreement would constitute the core of the trading activity. You're buying, you're selling rights. The contractual consideration which was due to the sole trader under the distribution agreement consisted of a series of fixed amounts called minimum annual payments, and a percent, that was part of the contractual consideration, and the other part of the contractual consideration was a percentage of any receipts from the actual distribution of the film. Alas, those receipts have failed to materialise, but the minimum annual payments were there as a contractual right that the appellant had at the earlier stage under the distribution agreement. The way that the trading loss would be produced was relied on the use of generally accepted accounting practice. What occurred was that the individuals had incurred the cost of acquiring the rights, but the idea of the scheme that accounting practice required those rights to be revalued in the first year and written down to a lower value to reflect the inherent uncertainty of any future profits being made. So in computing the profits in accordance with generally accepted accounting practice, what the traders would do would make this write down, which would go to the profit and loss account and thereby produce the loss. In practice, the traders didn't do that themselves. They were sent their accounts by accountants who had been appointed by Scion for that purpose. So they were all in standard form, but the loss would be produced in that way. And because that was the basic method of creating the loss, the write-down compared with the cost, the initial cost that the traders were required to bring into their accounts in accordance with generally accepted accounting practice would be based on the cost of the film rights, what they actually, what was the price of the film rights. And so the higher the price of the film rights, the greater the loss would be. And in order to enable the individuals to get the highest cost they could, the Scion Group provided finance by way of an interest-bearing loan to the appellant, and the loan was from a Scion entity in Guernsey, Scion Film Financing Limited, sometimes called Scion Bank or Scion Lender. And that loan was made on terms that the appellant would assign his contractual rights to the minimum annual payments which he was going to get under the distribution agreement to Scion Bank, and irrevocably direct that the minimum annual payment should be paid straight from Scion Distribution Limited to Scion Bank. Scion Bank...
It's an assignment by way of security.
Yes. Scion Bank, in turn, undertook, on receiving the payments, to discharge the appellant's interest obligations under the loan. And the minimum annual payments were set at a rate which matched the interest rate on the loan. So that was how the scheme was intended to work. The main argument being on trade, but this scheme sort of took place and entered into in 2007, 2008. In the years after 2007, 2008, we had a sort of series of cases from the tribunals and the higher courts looking at similar types of tax scheme, not sole traders, but partnerships entering into trade by entering into this sort of contractual package of rights. And the general message from the courts was that that kind of activity did not have the real badges of trade. So consequently, at an early stage, before the FTT decision or the FTT case in this matter, the appellant dropped the trading argument and accepted that he wasn't carrying on a trade, and therefore accepted that he wasn't due a trading loss. The revenue, however, maintained that although the appellant's activities are not those of a trade, the activities could properly be described as a business involving the exploitation of film rights, the income from which is charged separately to tax under Section 609 of the Income Tax Trading and Other Income Act 2005. So it's an independent tax charge on a business involving the exploitation of film. And the revenue said that the appellant is the person liable to the tax because under section 611 of general shorthand it's called ITOIA. If I say ITOIA, that's the 2005 Act. Section 611 provides that the person liable for tax charged under section 609 is the person receiving or entitled to the income. Now, the revenue don't suggest that the appellant has received the income. He plainly didn't receive anything. His net position is that he invested £300,000 into the scheme and has received nothing back. But the revenues say that under the structure of the scheme, the appellant was nevertheless the person entitled to the minimum annual payments because under the machinery of the scheme, they were applied by Scion Bank to discharge the appellant's interest obligations. And the FTT and the upper tribunal have upheld the revenues argument on that. So the issue in the appeal arises in the context of an appeal by one of the individuals who participated in the scheme. It's not a formal lead case as such, but there are a number of other individuals who've also been assessed to income tax on the same basis and who are therefore interested in the outcome of the scheme. And you may have seen that the amounts of tax involved on the appellant are sort of, we've got the years 2010, 2011 to 2012, 2013. No maps were paid in the first year. And there's sort of 58,000, 61,000, 60,000, all based on the amount of the minimum annual payments which were paid to Scion Bank, which were in the region of £139,000 worth of income. So that's the income that the revenue say is taxable on the appellants, even though there's no question that they've received any income at all. So the question is, were they entitled to it? And the appellant's case, put shortly, is that the effect of the assignment, coupled with the irrevocable payment directions, which required Scion Distribution Limited to pay the minimum annual payments direct to Scion Bank, the effect of those are that the entitlement to the minimum annual payments was passed to Scion Bank Limited. That's step one. And then the separate undertaking that Scion Bank gave to the appellant to discharge his obligations is not something that is taxable in the hands of the appellant. There can be circumstances in which the discharge of an obligation constitutes a receipt of taxable income in itself. It's capable of being taxable income. If Mr. Good was a director of Scion Bank, so he was within the scope of employment income tax, then discharging an obligation can be a receipt of taxable income. But there's no such relationship between Mr. Good, the appellant, and Scion Bank. So the discharge of that obligation doesn't fall within any head of charged tax. So in order to be able to tax Mr. Good, the revenue have to say that he's entitled to the income that was received by Scion Bank.
At what point do you say that test has to be applied? What chronological point?
That's very clear from the decision in Khan, I would say, that you apply that test at each time the income arises, the income falls due to be paid. So you ask, in Khan, the income in question was a distribution, and the Court of Appeal said that you must look at the time of the distribution. Did Mr. Khan have the entitlement to the distribution? In the present case, you must ask at the time the maps fell due, in April each year, did the appellant have the entitlement to that income?
Mr. Baldry, can I ask, just to understand, I suppose, the context a bit more widely? Your client put in £300,000. Did he lose that £300,000 once it was determined that this wasn't a trade at all, no losses, but the money has been swallowed up effectively in
Yes.
a scheme that doesn't work?
Yes.
So he's lost his £300,000, and he now then faces a tax charge on the maps, just the maps, because there was never any deferred proceeds. Is that right? So it's just the maps, and he pays income tax at whatever rate he's due to pay it at. I don't know what that would be looking back. And it came to about 60,000 a year, is that right?
60,000 tax, yeah. So
6,000 tax.
The maps was 130.
Yeah.
What the revenue is saying that he's for income tax purposes, he's had £139,000 of income,
Per annum.
taxable income a year, as have all the others.
Then let's say for 5 years. So very roughly speaking, and this may not go anywhere, it's just so that I understand where it sits. He's lost £300,000 and he's roughly speaking going to be faced, I think, with about £300,000 worth of tax. Is that right?
It's probably about 150,000.
I thought once you'd added in, because it's 5 years worth.
We have. There was one. The important qualification is that for the years in question take us up to 2013. In 2014, 2015, the maps weren't paid.
Got it. Okay. So that would fortuitously reduce his tax bill down a bit to something a bit closer to.
Yes, because I read that the interest wasn't pursued.
Well, I don't know whether the revenue. Hear what Melanie Fenton has to say, but don't know whether the revenue say that the mats weren't paid. We would say that makes a difference. They might say, well, he was still entitled to it under the contracts.
Okay, but as far as we've got 3 years worth of roughly £60,000 worth of tax per annum that's been charged. That's the cost. That's what we're talking about again. Oh, no. Okay, so sorry, you're right. You're right. There are 5 years in total, which the maps were paid. So they're not under this appeal, but there are sort of 2 more years of maps. At the First-tier Tribunal, it's worth pointing out that Mr. Good gave evidence, and Mr. Good produced the documents such as he had. The Scion group, the promoters of the scheme, were not interested in becoming involved in the case, so there is a limited amount of documentation in relation to those parts of the scheme which the appellant didn't have a direct involvement with, but there hasn't been any sort of disagreement as to how the scheme in general was intended to operate.
And the FTT clearly thought that the appellant was a very straightforward and honest witness.
Yes.
Said that effectively in terms.
Yes.
Adamant, I think, was the word.
Yes. Well,
I seem to recollect.
Yes, there were. We had two witnesses, two appellants, Mr. Ryan and Mr. Good. And Mr. Good, the main difference between them is that Mr. Good had some experience in films. I think he worked for Blockbuster Videos, and so he was able to to sort of take a view about which films to choose
Yes.
and which countries to exploit the films in, which was the main. Well, those really the only choices that the individual had. Where do I put the money? Which film do I actually choose? So, and that potentially would have, if you chose the right film, then maybe you might have got some distributable receipts, actual money, but not Mr. Ryan's evidence, on the other hand, is he wasn't interested at all in the films. He just sort of chose whatever country and whatever film added up to the 15% that he needed to put in. So he just calculated it by reference to components of a scheme without having any interest at all. So there was a bit of a difference between how they approached it, but that's water under the bridge because the tribunal held that it was a business. So could I take you to the sort of key sort of contractual documents that were part of the package that Mr. Goods was signed up to? That's in supplemental bundle 1. Tab, I won't take you through this, but if you're looking for how the scheme was sort of explained to the individual investors and how the overall structure works in a bit more detail, then the relevant document is the business plan at tab 16. And I think I have explained the basic point purpose of the scheme already. There's a little bit more detail on how the sole trader's capital contribution is used, which it might be helpful to have in mind. That's at page 328. It's the internal. These are the internal page numbers at the bottom of the page. So when they say how is the sole trader's capital contribution used, that is the combination of the £300,000 invested by Mr. Good and the £1.7 million that was the loan. And the capital contribution will be funded by a combination of the cash payment and the loan. And it's intended that between 92 to 93% of the capital contribution will be used to acquire film rights. Part of the balance will be used to pay the fees of Scion, and it's intended that the fee payable to Scion will be approximately 7% of the capital contribution, out of which Scion has agreed to pay certain initial costs. So the investment that Mr. Good made wasn't particularly earmarked for one thing or the other, but we know that £300,000 were paid in, and out of that total amount, Scion took its fees, and one might infer that they took all their fees came from the £300,000 invested by Mr. Good. The package of documents that were presented, and essentially the evidence was that one got this package of documents, one had a choice as to how much you would invest, but once you've made that decision, there was really no other choice to be made apart from the film itself. All the other sort of aspects of the contractual documentation were sort of prepackaged and ready to sign. And so the registration agreement provides the first sort of demarcation of the difference between Mr. Good's investment and the loan. So that's on page 355. so in registering for the scheme, he has to say how much cash he's putting in, and so in the box at the bottom of the box, it's a little bit wording is lost on the left-hand side, that it's cash payment of £300,000, 15%, and then there's the finance from Simon Bank of 1.7 million, 85%.
Was it always in that ratio of 15 to 85?
Yes.
So you work out how much the loan is going to be based on, contingent on what the investment is.
Yes. Yeah. So I think on the bottom right-hand side, the minimum of 1 million, an increment of exactly 50,000 thereafter. And under this, part of the registration agreement, Mr. Good had to make various promises. So one, he agrees that he does intend to establish a trade in the acquisition and exploitation through film rights, and that you intend to contribute as capital to that trade, the capital contribution set out above. And then various other commitments were made under the registration agreement, including at 4 on the bottom of page 356. Mr. Good irrevocably authorised and consented to sign, delivering all loan documentation to the lender and the loan security. And over the page, on page 357, at 6, at the top of the page, he acknowledged his understanding that he will be required to enter into security arrangements with the lender, pursuant to which he will grant in favour of the lender a charge and an assignment of inter alia your right, title and interest in part or all of the sale proceeds payable to you from exploitation of the film rights acquired.
Sorry, can you just, that last point, sorry, I just can't.
So that's paragraph 6 on page 357.
It's one document, isn't it?
Yes.
It's not a separate, it's not a charge and an assignment.
No.
It's an assignment by way of charge.
Yeah.
In fact, we will come to look at it.
We'll come to look at it, yes.
But it's not two separate documents.
No, certainly not. No. And so the loan agreement is actually, in terms of the order, it's easier to interpret the loan agreement once you've looked at the acquisition agreement and the distribution agreement. So if we can just look briefly at the acquisition agreement, that is in supplemental bundle 2. At tab 23. So a sort of full commercial document with all the terms you might expect. And on page 390, you get essentially what it was that Mr. Good was acquiring under this proposal. And he entered into this arrangement for 2 films. One of them was tenure, and this is the one dealing with tenure, and the other one was a film called Repossession Mambo, but there isn't any real material difference between the two sort of sets of agreements. we've got all the set for tenure here, and basically at paragraph 1, the Scion Rights Limited assigns to Mr. Good all its right, title and interest in and to the assigned rights. And then at 1.2 you see the sort of the split that was a choice that Mr. Good made, because he had to choose not simply the film, but the territories to which those rights, the film rights, the potential to distribute the film are related, which would each have their own distinct purchase price. So the total purchase price for those rights was 133,293. So that's what he acquired under the acquisition agreement, which was signed by a Scion entity on his behalf. And again, on the same day, 4th of April 2008, he entered into the distribution agreement relating to the film rights, and that's at tab 24. So here the contract is with Thomas Good and Scion Distribution Limited as purchaser, and at 1.1 he assigns to the purchaser for the term all his right, title, interest in and to the distribution rights, and it's the same rights for the same film, the same territories. And the key clause in this is the distribution receipts entitlement at paragraph 3 on page 432, where it says 3.1, in consideration of and subject to a valid effective assignment of the distribution rights subject to paragraph 1.1, the vendor shall be entitled to the following payments. 1, the minimum annual payments calculated in accordance with paragraph 3.3, and then 2, the amount, it's essentially saying the amount of the defined proceeds, which are amounts that actually represent receipts collected from the distribution of films, if any, capped at 200% of the purchase price. And so the defined proceeds are set out at paragraph 3.2, and essentially formulas which give you the correct percentage of the distribution receipts which are actually taken in by the entity to which Scion Distribution assigned on its rights. So there was a potential for distribution receipts to be, defined proceeds to be received under this agreement, but that would all depend on whether the films prospered. So 2 categories: minimum annual payments, fixed, defined proceeds, dependent on actual real receipts. And 3.3 sets out the minimum annual payments, that by way of a minimum entitlement, purchaser shall pay to vendor to be received by vendor on 5th of April in each year from 5th of April 2009 up to and including 5th of April 2015 the following amounts, and then 0.082 times calculation amount, the above payments being referred to as the minimum annual payments, and the 0.082 figure can be explained when we look at the loan agreement, because the interest on the loan agreement was expressed to be 3% over Barclays' base rate at the time of the drawdown, and at the time of the drawdown, 3% over Barclays' base rate equal 0.82. So within the overall matrix, the minimum annual payments were designed to be based at the same rate as the interest rates. And the issue in this case is whether Mr. Good was entitled to those minimum annual payments so that he's liable to income tax on them. As part of the package, you've seen that Mr. Good was required to make an assignment and to charge all in one document the minimum annual payments, everything he was entitled to get under the distribution agreement, and that took place in two stagements. There's a security assignment at tab 38. This was the document that we couldn't find in the electronic one before the upper tribunal. It was actually there. The hazards of electronic one, but the upper tribunal did look at it when we put in our written submissions. Noted it was undated, but as this was a condition precedent to have entered into this before getting a loan, the inference can be safely made that it was entered into on or before 4th of April. Under the deed of security assignment, it recites a little deed that he had agreed to assign his interest in the film rights by way of security for the loan. That must be a reference to the registration agreement, and it is now agreed. You agree in return for a lender agreeing to advance you the loan to comply with your past, future obligations and liabilities to the lender, including in particular your obligation to repay lender the loan, all interest thereon, and other sums due thereunder, the debt when the same falls due for repayment, and these obligations are for the purpose of this deed described as the secured obligations. Then he makes the undertaking to pay. You shall pay and discharge each of the secured obligations when due. And then 3 is the assignment and charge. So the structure of this is 3.1. Mr. Good hereby unconditionally and irrevocably assigns, with limited title guarantee, for the payment and discharge of the secured obligations to the lender by way of security, all of your present and future right, title and interest in the film rights and the benefit of your present and future rights under the acquisition agreement, including the distribution rights acquired thereunder and the distribution agreement, include without limitation the benefit of all income, all monies payable to you in respect thereof, including the benefit of all proceeds payable to you in respect of your distribution rights therein, and all royalties, fees and other payments and income paid or payable in relation thereto, and all sums payable to you by way of repayment of the purchase price as defined in the acquisition agreement, excluding the reserved collateral. By way of security, he irrevocably assigns his right to the maps, which are part of the income from the distribution agreement. We'll look at reserved collateral below, that's at 3.3. He then, at 3.2, he unconditionally and irrevocably charges with limited title guarantee by way of a first fixed charge for the payment and discharge of the secured obligations to the lender by way of security to the extent not assigned under clause 3.1 above, all the subject matter thereof, together with the benefit of the proceeds payable to him.
What does limited title guarantee mean? Does it matter?
That's the standard
Just what it always says.
way of assigning by way of security. How this operates is that he assigns all his rights to Scion Bank, but then clause 7 provides that if he's repaid in full the secured obligations to the lender, then the lender reassigns the collateral back to him. So 3.1, the assignment, 3.2, the charge, to the extent anything's not assigned. 3.3 explains what is not assigned, and 3.3, the reserved collateral, means the amount payable to Mr. Good under the distribution agreement by application of the payment directions, excluding for the avoidance of doubt all amounts payable under the distribution agreement which are payable to lender pursuant to the payment directions. So as we'll see, that under the payment directions, 55% of the distributable proceeds, the amounts, the variable amounts, are to be paid direct from Scion distribution to Scion lender, if they ever rose. The end of all that then, Mr. Good has the possibility of getting income from 45% of the defined proceeds, and that amount of the 45% is not subject to any assignment. So Mr. Good, had the films produced any distributable receipts, would have been entitled to 45% of them, and they were not subject to any payment direction, and no one would be disputing that if he got any of that income, he would pay tax on it.
I mean, without wishing to sort of stand back too far,
no.
I mean, the document at tab 38 is the key document in the case, isn't it?
That document, together with the notice of the assignment and the payment directions, I think one takes into account. But they notify.
This is an equitable assignment, isn't it?
Yes, it's an absolute assignment.
No, it's not. It's an assignment by way of security.
But it can be an assignment,
no.
Even though by way of security, if it's if what is being transferred over is the legal chose.
You can't have a statutory assignment by way of security, can you? At law, it's not possible as a matter of law.
Well, it may be possible, but my submissions don't.
Section 136, Law of Property Act. You can't. An assignment by way of security is not a valid legal assignment. It's an assignment in equity only.
Yes, I had understood that there were circumstances that it could be, but my arguments don't depend on it being an equitable assignment or a legal assignment, because it's clear from the test, I will say, that what one's looking for, who has the right to the income.
We may have to look at what the nature of an assignment is, but certainly as I currently understand the law, an assignment such as this can only be an equitable assignment. It's a charge.
Yes.
It's an assignment by way of security, it's a charge,
Yes.
which doesn't actually transfer ownership of the shows to the assignee.
No, it is sufficient, coupled with the payment directions, we would say that is sufficient to give the right to the income to Sion Bank Limited. And that's what I need to show.
Okay. All right, well, we may come back to that, but I just wanted to put my
Okay.
A card on the table
Yes. Yeah. No, that's
early on
Yeah.
in the piece.
yeah, that's important. We'll look at the cases that do look at the situation where you've got some trusts involved, and it's clear that merely having legal title doesn't make you the person with the right to the income.
Okay.
In your case, as you're putting it, before we go any further down that particular line, is that the assignment together with the payment directions together, you say, establish an assignment of the income.
Yes.
Which take your lay client out with section 6.
Yeah. The person with the right to the income at the time it arose was Sion Bank, and not the appellant. Shall we turn to the?
Just if I can just pick up my lady's point, can we keep an eye on I think it's section 611, two words. There's received and entitled.
Yeah.
And I expect we'd all agree that the received, it's quite clear that the bank receives the money. So that bit falls away. So it's just entitlement that we really have to focus on.
Yes, absolutely.
It's only stating the obvious, but
no. Yes. Is this a case where the person that's received the income was not the person entitled to the income? And say, well, if you look at the documents as a whole, then the person that received the income was the person entitled to the income in this case, and the fact that they thereafter made a disposition of the income that provided a benefit to the appellant is neither here nor there. And that comes out in the Khan case.
And putting it colloquially, the revenues say that the late arrival of Khan hold that argument below the waterline.
Yes, and we say that.
Well, you say not.
Yes,
that's
obviously. We
takes us back to your initial submission of Khan is critical.
Yeah, absolutely. And the Khan case, it's what we say the Khan case makes important is you're not looking at the end result of the transactions. What you're doing is at the moment that the income was paid, who had the right to it.
I understand. Thank you. That's very helpful. So you're taking us next to the loan agreement?
The loan agreement, yes. That is tab 19 of the supplemental bundle 1. Well, actually, sorry, before going to the loan agreement, I think the one next document that does come are the payment directions. So, apologies, back to supplemental 2.
tab 25, I think, isn't it? Is it the assignment, notice of assignment and payment direction?
Oh yes,
Rather?
thank you.
Tab 25.
Tab
I think.
25. So this is a document which both notifies Scion distribution of the assignment which has just taken place that we looked at. So the parties to this document are Scion distribution, the appellant, Scion film financing, the lender, and Scion rights. And this document says, pursuant to the loan agreement, entered into between Scion Bank and the sole trader, Scion Bank has agreed to make available a loan to the sole trader to enable the sole trader to purchase certain distribution rights in the film. And then over the page, what are they agreeing to? 1A, pursuant to the security agreements entered into by Scion Bank and the sole trader on or before the date hereof, the ST security, that must be a reference to the document we just looked at tab 38. The sole trader has, subject to the terms of the same, assigned to Scion Bank all of sole trader's benefit under the distribution agreement, including, without limitation, the benefit of all income, all monies payable to sole trader in respect thereof, including all the proceeds payable to sole trader in respect of the sole trader's distribution rights, royalties, fees, etc. Again, excluding the reserved collateral, which is the 45% payable to Mr. Good, until full payment and discharge of the secured obligation. Sole trader and Scion Bank hereby notify SDL to pay the following to Scion Bank, or as Scion Bank may direct, until repayment in full of the aggregate amount of all indebtedness owing pursuant to the ST loan agreement. The minimum annual payments, as such term is defined in the distribution agreement, and then 55% of the amounts due to the sole trader under paragraphs 321 and 322 of the distribution agreement. There's the irrevocable and unconditional direction made by Scion Bank as the assignee of the rights to pay the minimum annual payments to Scion Bank. Then Scion Bank undertakes to sole trader to apply all sums received from Scion Distribution Limited pursuant to clause 1A1 above against the interest due and owing and repayment of the principal amount of the loan advanced under the ST loan agreement. So that's the undertaking made by Scion Bank that it will apply the sums that it has received in discharge of the interest obligations. And it is expressed in terms that it assumes that Scion Bank has received what it's received, and then so that is the receipt of the income, and then having received the income, the undertaking is that it will apply that sum against the interest due and owing and repayment of the principal amount of the loan. So on the 5th of April, when the minimum payment fell due, it would be paid and received by silent bank, we would say, well, at that point, that is where you look to see whether the income tax charge is satisfied by that receipt by Scion Bank, and whether Scion Bank was the person receiving and entitled to the income. And then the undertaking that Scion Bank then made would come into effect on the 5th of April, and Scion Bank would use the money it's received to discharge the obligation of Mr. Good. Is that a taxable benefit in some way that falls within a head of charge to tax? No, Mr. Good isn't an employee or anything like that. There's no separate provision that could say that would bring that discharge of Mr. Good's obligation into charge to tax. That's the security assignment coupled with payment directions. And so now we can look at the loan agreement in supplemental bundle 1. Tab 19. So the repayment at 4.1 on the bottom left of page 363. Mr. Good undertakes to repay any part of the loan then outstanding, together with all amounts owing to the lender under this agreement, the outstanding loan in full or before the 5th of April following the 6th anniversary of the last drawdown comprising a part of the loan. So 4.4 sets out his obligations. On or prior to the repayment date, your obligations to repay the principal sum of the loan, excluding any accrued interest principal, will be limited to 55% of all defined proceeds, all entitlements thereto and the debt represented thereby, and to otherwise from your rights, entitlements and interest in respect of or deriving from any property assigned pursuant to clause 3.2 of the security, and the property charged pursuant to 3.2 of the security, and you shall have no obligation to repay the principal to the lender from any other assets or resources. So I think both the tribunals are picked up below a limited recourse loan as to capital. And then 4.6. Notwithstanding anything to the contrary in this agreement, in the event that the outstanding loan shall not have been repaid on or before the repayment date, your obligations after the repayment date to repay the outstanding loan hereunder are limited to payments in respect of 100% of all defined proceeds. So after the repayment date, that split between it's not simply the 55% that can be used to apply the set against Mr. Good's interest obligations. The whole amount of distributable receipts came in are allocated first to discharging the debt. Otherwise, from rights, entitlements, and interest in respect of or deriving from any property assigned pursuant to clause 3.1. So then, going back, although I've taken you to this last because it's easiest to understand what it's talking about once we've looked at the other documents, but in fact, this was this loan was made on condition that all the other security documents were entered into. That's made clear by clause 5. that the liability of the lender to make available the loan to the borrower is subject to the delivery to the lender in respect of each drawdown of the following in form and substance satisfactory to the lender. A, the security documents, the fully executed deed of security to be granted by the borrower to the lender in a form approved by the lender, under which the borrower assigns inter alia its share of the income from the exploitation of the film rights to the lender, plus all the other agreements. So the loan was only going to be made if Mr. Good had already assigned his rights to the minimum annual payments by way of security to Sion Bank, and had irrevocably directed that the amounts in question would be paid by Sion Distribution to Sion Bank. Well, if Sion Bank had irrevocably directed. So that's why I mean, quite usual for this type of package. Everything is sort of sewn up in advance, because there are potentially valuable rights being transferred under these contracts. An entity such as Sion or the film studios would be sort of jealously guarding what happens to them, when in fact, although the rights are granted for the purposes of the scheme, all the economic interest and value is withheld by Sion, and so that all these individual traders don't go off with valuable rights on their own. The interest on the loan, this picks up the point of the relationship between the interest and the minimum annual payments. That's at clause 7, where it says that interest is at the rate of 3% above the base rate of Barclays. That takes us to the 0.82. Clause 10 again reaffirms the borrower's requirement to sign the various security documents in the lender's form. So those are the core documents. What did Mr. Good do with those? It's a relevant point. So that the revenue say, well, look, he's got to be entitled to these because that's how he accounted for them in his own accounts. And it's true that in his own accounts prepared by Sion, the amount of the expenditure of the assets was treated as a cost of his, and the minimum annual payments were included in his turnover for the purpose of computing his profits for the purposes of in accordance with generally accepted accounting principles. We do have a profit and loss account. Sample profit and loss account in supplemental bundle 1 tab 15. Perhaps unsurprisingly, because the scheme was intended to work in the way it was, the scheme's accountants, Sion, treated the minimum annual payments as being part of his turnover for the purpose of a slightly different exercise of calculating for income tax purposes what are the profits of the trade if one's looking at a trade, the tax charge on trade is not simply on income, it's on this sort of notional concept of the profits of the trade. So in computing the profits of the trade, the accountants included the minimum annual payments within that figure of income at the top of page 315. Indeed, that's the...
Is that, there's nothing else, is there? It is just the map for that year.
That's essentially it. There may have been some revaluations that were still going on, but in essence, the substance of it was the minimum annual payments. And then, why didn't that produce a tax charge? Well, under the idea of the scheme, the corresponding interest obligation was taken as a deduction.
Can I just
Yes.
quickly, I'm just trying to find that figure. It's the one at page 319, isn't it? And so it's accounted for as the right to future income, isn't it? Is that right? 136,529.
That's how it is stated to be, yes.
So is this right? I mean, I was going to ask the question at some point, but I might as well ask it now. What's the definition of income? It's not cash, is it? It's the right to receive. It's the receivable.
The income is the amount which is receivable.
Yes. So, in other words, as I understand it, you put into your accounts the amount of the receivable at the relevant date.
Yes.
And if you don't receive it in cash, because it's not paid, it may become a bad debt.
Yeah.
But when we talk about income, we're not talking about cash. You know, it doesn't only become income when you actually get the money in your hand.
No.
It's the right to receive.
Yes, and there's a distinction between the income that you're taxed on if you do have a trade, is that what the Act charges are the profits of the trade.
Yep.
So you have to go through this computation of working out, in accordance with generally accepted accounting principles, what your profits are, which may have absolutely very little to do with any actual income. You know, you may have trading receipts which have an income quality within that, but what you're actually being taxed on under the trading charge is your profits.
Okay.
So
where I'm going with this, just so again, so you understand where I'm either barking up the wrong tree or asking a relevant question, is we have to be focused on who was entitled to something. You say at the time that the right to payment
arises,
crystallised.
Yes.
And I'm asking really, I suppose, for the distinction between, is it the receivable, the right to the receivable we're looking at, either shows in action, represented by the debt, or is it the right to actual receipt of money? They're not the same thing.
No. Well, I would say the right to the actual receipt of the money. I mean, you've got to have an entitlement to income is what comes in. You can only be taxed to income on something, an amount which is of an income nature. You don't actually have to receive it if it's in a bank account to your name. Well, that's treated as a receipt.
The reason
you do have to identify an amount of income which is received by somebody.
Because one of the very simple distinctions that seems to be being attempted may divide the two sides in this, and it may not be, but let me just hear me through, is that the contractual rights to be paid the maps were the subject of the security assignment that we've looked at. And if one were to ask the question, who owns or who is entitled to the maps, you are looking at entitlement to the shows in action, the receivable, the debt coming due, owed by the purchaser of the distribution rights.
Yeah.
If you are, however, looking at the right to receive the actual money
Oh yes, that's it. Yeah.
flowing from that receivable,
Yeah.
the question is, are you actually looking at the right to be paid the money, to have the pounds and pence into your bank account, in your hand?
I would say that.
And I'm just trying to be clear what we are actually looking at. Is it entitlement to the receivable which generates the money payment, or is it entitlement to the money payment itself?
It's not the entitlement to receive. It's the entitlement to the receivable.
To the receivable. Because that raises the question of who therefore remains or is the owner of a shows in action subject to an equitable assignment by way of security.
Well,
is it an assignment by way of security? I won't go into that again. If we can think about that. Is it the assignor or the assignee? And I just want to be very clear what we're actually trying to look at.
Yes.
But what does the tax statute tell us to look at? Is it the receivable or is it the money?
Yeah, I mean, I think what Khan is helpful on that is it's saying, well, who has the right to the money? And the cases say that...
a moment ago you said it was the right to the receivable, now you're saying it's the right to the money.
Well, I mean, the right which produces the money.
They're two different things,
Yeah.
and that's the key.
Yeah.
Actually,
But
it could be the key actually to bear in mind, because you may say that they are both in one and the same person.
Yeah.
It might be said, again just putting my cards on the table so when we go to look at the authority we keep this in mind.
Sure.
My current understanding of the law in relation to assignments by way of security, which can only, in my understanding, be equitable assignments because they may be irrevocable and unconditional, but they're not absolute, which is what is required at law under the Law Property Act, is that the owner of the shows remains the assignor, and equity just gives rights to the assignee to bring proceedings to enforce payment.
Yeah.
So if you're asking who owns the shows, it will be the assignor, not the assignee.
Okay.
And therefore the answer might be different if you ask the question who is the owner of, or who is entitled to the shows, and whether you ask who is the owner or entitled to the money generated by payment of the shows, which may be, in this case, the assignee, the creditor,
Certainly that,
the bank. And I'm just putting that analysis on the table so that when you then go to the authorities, we can have that question clear, because I may be wrong in my analysis.
One of the
But I need to understand that.
One of the cases that Khan considered was a case, a trust case, Williams and Singer, where you had a split of legal title and equitable ownership, and the shares, the trustees of a trust held some shares.
But this is not a trust. This is a charge. This is an assignment by way of charge, not an assignment by way of trust.
No, there's no exact ludicrous. But what was said in that case, that the fact that the trustees had the legal title didn't make the trustees the persons liable for the tax.
I don't want to go too deeply into this because it may not help.
No.
but because we're about to wade into car, I just wanted to sort of make sure that I've put my sort of questions on the table before.
Well, I hope I'll address that when dealing further with CARM, but essentially, that when we look at the cases, they're not the question of who is the person entitled to the income for tax purposes. It doesn't delve deeply into who had the equitable right, who had the legal right. Standing back from it, well, who had the right to the income in this case.
Okay. That just begs the question: what's the income for this purpose?
Yeah.
So, which is where I came in about 5 minutes ago. So
yes, but
I'll back off.
So income is income is the actual payment of income that.
But curiously, as you point out, according to generally accepted accounting principles, these accounts, you do account. I mean.
Yes, but that is because the charge isn't on income. The charge for trade is on profits.
But maybe, but the accounts. Sorry, you've got competition from behind and outside. Take.
Yes, so I mean, I think trying to. Yes.
So make sure you take the instructions fully.
Yeah.
I don't want to interfere.
I hope I've made the point already, but just to be clear that the whole basis on which the profits of a trade are computed and taxed, namely looking at generally accepted accounting principles.
Sure.
That is completely irrelevant for the purpose of the separate charge on.
I understand that.
Under Section 609, which is on the full amount of the income arising.
I understand that. I mean, my question, in a sense, was almost more simplistic, which is simply that under the heading income, these accounts included the right to future income, and I was just questioning for myself whether.
However, that is expressed in these.
I mean, the case can't turn on how an accountant draws up accounts. I don't suspect.
Well, if the question was we were looking at what are the trading profits, then how the accountant drew it up would be very relevant indeed, and there would have needed to be expert evidence to establish what the trading profits were and how they were computed, etc. But that's. Completely different to the present case.
You'll be able to show me that was how income is defined for the purpose of Section 611. I think it is. Yeah, it's the full amount of the income. The income itself is not defined. It's in the cases. It just say it's the amount that comes in. It is the thing that is being charged is what is received. So it is the payment that is received, and then if that is the income, if somebody else is entitled to what was received, then that's where the charge can be made on somebody else. But the income is always the actual thing that is received. All right. Well, enough for now.
Yeah. So, if we think we've completed the documents anyway, so it probably is helpful to go to the CARM decision. There's one further document that you may or may not find helpful. It's just a diagram to show more broadly what is happening Now, this isn't. I don't think this was an agreed document as such, and one's got to be a bit cautious. But at tab 32, supplemental bundle 2. This is a diagram which sets out how the sole traders fit into the overall pattern. So you see there the relationship between the outside parties, Scion and the sole traders are set out here. So at the top in the middle we've got sort of a studio, KOF Capital, and then the dotted line going down from KOF Capital to Scion Rights constitutes film rights, which are passed to Scion Rights, onward passed to the sole traders, and then they go off to the right to Scion Distribution, and then it's Scion Distribution in turn passes them on to a distribution company. And then also this shows the sort of flow of the loan finance, and we see it's supposed to say that the cash personal loan on the left is the £300,000. The Scion loan comes down 85%, that's the 1.7, and that is paid over to the sole traders. The bulk of it goes back to Scion Rights, who originally provided the funding that went to Scion Film Financing, and Scion fees are taken out to a Scion entity. And again, so that shows that the 45% defined proceeds are what is the only thing that the sole traders could actually receive. That's paid from Scion Distribution to the sole traders. 55% of the minimum annual payments were under that structure due to flow to Scion Film Financing around the outside right circle. It depends how you draw the lines. So those were the key documents. The decision in Khan.
Mr. Baldry, can I, at the risk of going backwards a bit, I realised I haven't quite taken on board with the P&L. Can we just go back to the P&L, page 315, please?
Yes.
Just to understand how it was all meant to work, because this is a meant to work document, isn't it? But it didn't work like this in the end because it wasn't a trade.
Yeah.
So you set up the income from the trade being the maps, and as you said, there may be some other adjustment figures that you put in there, but I think here we've worked out that it was just the maps that came in as income. And then on the overhead side, you've got the interest, which is a little bit more than. So you generate a small loss at the end of it. I thought I had in my mind that the point of all this was to generate enormous losses.
Yes.
So I just wanted to ask how. I'm missing something.
The main this is for 2012.
Yeah.
The original first year was 2007, 2008, and it was the first year where the large write-down took place. So I don't know, we've got the accounts for 2007, 2008. There were, in the first year of trading, the accounts would show the costs of acquiring the.
You can see it at 319, the bottom of 319.
Yeah, exactly. Got it. Okay, so just
We've got the revaluation technique on 318.
Yeah.
How that's going to work.
Yes, so the revaluation is taking place, and it carries on, but after the initial revaluation took place, the majority of the income that was left were the continuing minimum annual payments, together with the supplement of revaluation.
So was the benefit of it, was a first year write down that gave you a big loss in year one, did it?
Yes.
And then what we're looking at is a subsequent year where it's sort of, if I can put it colloquially, it's sort of ticking along, making you a small loss every year.
I think that's a fair
Is that about right?
description. Yes.
But the
yeah.
benefit, the tax benefit if it had worked was a front-loaded big loss that you could do sideways relief on.
Yes.
So that was the incentive.
Yeah, the first year was the write-down, and there were no minimum annual payments. But so there.
And you can see that. Sorry, you can see that, can't you? Page 319. You've got a £1.7 million loss on Mambo.
Yes, and that would have been the. We've got 10-year. That was 300,000. I think Mambo happened to be the larger, film.
Thank you. Okay, I think I've got that. Thanks very much.
Yes. So in terms of how the sort of the activity sort of rumbled on after the first year, the significant thing was were the maps of coming in and going out.
But sort of equally an opposite, matched by the loan interest. In fact, a little bit more loan interest than the maps. Thank you.
So return to Carl now.
Yes, and well, actually, just before going to Calm, there's one case that crops up in Calm that it is worth having a look at, just to sort of ensure what it says. Wood preservation and prior, one about mere legal shell. So that's in the authorities.
Have 8.
And this is the first of a line of cases which considered the concept of beneficial ownership in the context of groups of companies. And although the upper tribunal in this case agreed that Khan said this was not a helpful starting point, which when we come to the upper tribunal, actually they do bring in this concept of whether it was beneficial ownership or was a mere legal shell as being part of the test that they needed to apply. But it is as Khan points out, in a very different context. I won't take you to all of the line of cases, but wood preservation and privacy explains what this sort of statutory context of this test essentially we're looking at groups of companies or companies under some form of common ownership, and where you have companies in common ownership, whether under a group or a consortium, then there are rules which effectively allow the different companies to be treated as a single economic entity, so that losses, for example, can be transferred from one company to another without any sort of tax consequences. In the present case of wood preservation and prior, the particular test that allowed losses to be transferred from from a parent company to a subsidiary was 75% beneficial ownership. And the facts of this case were that a company called Silixine was the beneficial owner of wood preservation and prior. And what happened was that it entered into a contract to sell the shares in wood preservation and prior on terms that once the contract was signed, the parent company was prohibited from selling the shares to anybody else, and was prohibited from taking out any distributions from the company. The only nuance was that the contract was subject to a condition which could have been waived by the purchaser. After that contract was entered into, the parent company transferred a trade with losses down into wood preservation and prior. And so the question was, well, was that company entitled to those losses, given that Parliament had said that you only get that form of relief if you've got 75% beneficial ownership. So that was the context. You're looking at beneficial ownership of an asset in that parliamentary context. So various sorts of statements were made that were sort of picked up by the revenue. In fact, before the First-tier Tribunal, this is really one of the main planks of the revenue's case. That what we've got here is something where Mr. Good in the present case couldn't be described as being a mere legal shell. It went beyond that. So the arguments of the parties in the context of that 75% beneficial ownership are set out in the decision of Lord Donovan at 1095. So timing in all these cases is important. We have the contract followed by the disposal of the trade and the associated losses. Question: in light of that contract, did the company have beneficial ownership of its subsidiary? A little g, the arguments are yes, say the taxpayers. There was no binding contract for the sale of the shares until the condition was formally waived 9 days later by the buyer, and so Silixine remained beneficial owner of at least 75% of the shares. No, says the Crown, it was not the beneficial owner in any sense relevant to the purpose of Section 17 of the Finance Act 1954. The position, even before this condition was waived, was this: first, Silixine could not have disposed of the shares to anybody else. Had it tried to do so, it could have been restrained by injunction. Second, it could not declare or pay any bonus or dividend on its shares. It had specifically precluded itself from doing so. Third, it would have been bound at any time actually to transfer the shares if British Ratin waived the condition in question, which in law, at any rate, it could have done at any time after the contract was was signed. That the shares were, in a word, like a tree which the owner could not sell, could not cut down, which could not enjoy none of the fruit. The question is this state of affairs beneficial ownership for the purposes of section 17? Expression is not defined, but it's useful to remember what the legislature was doing. So it looks at the particular purpose of the legislation. You've got to have an identity of interest of the beneficial ownerships. And it says that at C, if one finds us here that the company which made the losses is still the legal owner of the shares is bereft of the rights of selling or disposing or enjoying the fruits of these shares, then bearing in mind the purpose of section 17, it would be a misuse of language to say it still remained the beneficial owner. And then Lord Justice Harman agreed, and it's he who uses the sort of phrase mere legal shell over the page at 1097. Where he says that section 17 defines that deals with ownership. It then goes on to say that where the word ownership is used, it means beneficial ownership. That means, I think, an ownership is not merely the legal ownership by the mere fact of being on the register, but the right, at least to some extent, to deal with the property as your own. After accepting this offer, Silixine was not able to deal with the property in any way at all, as already been pointed out by my lord. Therefore, it seems to me to be a contradiction in terms to talk about beneficial ownership in Silixine. There was no benefit at all in their ownership, it was mere legal shell. In the context of that particular set of rules, looking at ownership of assets, that concept of the mere legal shell was introduced. I don't think it's ever before been used to sort of answer the question about, well, who's liable to income tax on a stream of income. And I think that's what the Khan confirmed. So we can go to the Khan next. That's Authorities Bundle 2 at tab 43. So the facts are set out in the head note, and essentially what happened in Khan was we had the existing shareholders of a company. The company had distributable reserves of £1.95 million, so they could have taken the shares out themselves, and had they done so, there'd be no dispute. So instead, they entered into an arrangement, contractual agreement with the accountant of the company, Mr. Khan, and the idea was that they would, instead of taking out the distributable reserves themselves, they would sell the shares to Mr. Khan. He would take the distributable reserves out, but on terms that he would pass the value of those distributable reserves back to the company, back to the original shareholders, and because they structured it in that way, Mr. Khan was the person that was actually the shareholder. The fact that he had a corresponding obligation to pay the value of the distribution to the individual shareholders didn't make any difference, according to the Court of Appeal. Mr. Khan's argument was, well, this is essentially one transaction. There's one thing going on here. There is a set of contracts that were all intended to operate together. The vendors wouldn't have sold the company to Mr. Khan unless they were to get the money out. Mr. Khan wouldn't have agreed to buy it unless he was going to have the distributable reserves out of the company so he could pass on to the vendors. Therefore, the proper analysis is that Mr. Khan was just in the middle, sitting there as a conduit. Yes, he took the money, and yes, he passed it on, but you could ignore those two steps and regard it as a straightforward distribution paid to the vendors. That was essentially the argument of Mr. Khan. So if we look at the statutory provisions that the court had to consider in that case, they're set out in section paragraph 5 of the judgment on page 525. A distribution for income tax purposes under section 383 is defined simply as any other distribution out of the assets of the company. It certainly covered the buyback of shares that the company had agreed to do with Mr. Khan. And then over the page at paragraph 6, section 385 identifies who is liable to pay the income tax chargeable on a distribution under section 383(1), and you'll see that the wording is very similar to section 611. The person liable for any tax charged under this chapter is the person to whom the distribution is made or is treated as made, or B, the person receiving or entitled to the distribution. The present case only concerns 385(1)(b). So it's the same statutory phrase in that case, and at 7, Lord Justice Andrews makes the point that it's used in many other provisions, including section 611. A distinction between the old trading cases and distributions they pick up at 8 was that prior to the rewrite which had been made in Itoya, the old Schedule F hadn't specified who the person liable to the tax was. And under the old legislation, I think trades, Schedule D, had always had this phrase, the tax is charged on the person receiving or entitled to the income. But other tax regimes, such as the tax on distributions or the tax on employments, didn't have that sort of same phrase. But by looking at the history of the section 385 and the explanatory notes to section 385, the court sort of noted that even under the old regime, the position had been that where the distribution actually belongs to someone other than the recipient, it's treated as belonging to someone, or it's treated as belonging to someone other than the recipient, then that other person is liable for the tax charged. And so they thought that indicates that the person entitled to the taxable income means the person to whom the income belongs. In the case of a dividend or distribution by a company out of its profits, that will usually be the owner of the shares. So essentially, they say that under the old regime, although it hasn't expressly stated who was liable, then nevertheless it's the person that the income belongs is the test. Parliament having introduced Section 385 to sort of make the rules of distributions fit in with the way that tax is charged in other parts of that, actually didn't significantly alter the position, and gave some guidance as to what entitled to means. And then over the page, it's worth noting at paragraph 11 that the court accepts that the phrase receiving or entitled to must be a consistent meaning wherever it appears in Itoya. So what's said about section 385 is equally relevant for our purposes.
If you're not going to go back to it, can I just take you to go back to paragraph 10?
Yes.
And I'll pick up the question I was sort of floating with you before. This appears to make it clear that there is a difference between receipt and entitlement.
Yes.
And so, in the same way as what was said on the previous page at paragraph 8, just below the quote, the person receiving the money, the distribution, is not necessarily the same person who will be treated as entitled to it, because entitlement seems to go with the shares, the tree that generates the fruit, if I can use the wood preservation metaphor for a moment.
Yeah.
And so, to take the example I gave you before of a receivable which is then paid, and the entitlement would seem to relate to the receivable and who owns the receivable, whereas receipt looks at the money which is paid.
Yes.
And Lady Justice Andrews was suggesting that the effect of the wording received or entitled to, receiving or entitled to, means that you can be taxed on either basis, one of which looks at the money, the other one looks at the
Entitlement.
The tree, the shows in action, whether it's a share or a receivable which generates it.
Yes.
I mean, do you dispute that?
No. But what I would say, that if you have an assignment of that right, even if it is an assignment by way of security, if there's an equitable assignment of the right, then coupled with the payment direction to make the payment from one person to the other, then the entitlement passes.
So your point is, well, your case really, is that the entitlement is that you accept completely paragraph 10, and that's undoubtedly the case. But your case is that on the facts of this case and this scheme, the entitlement had passed.
Yeah, the entitlement passed at the outset, except that absent the security assignment and the payment directions, then the entitlement started off with...
You see, the analysis may be that the effect of the payment direction is that to ensure that the money is received by the bank, the lender. But if you are looking at entitlement to the shows in action, the tree that generates the fruit, the question is, what is the effect of an equitable assignment or an assignment by way of security? Because if, in fact, that means that the property, the tree, remains in the ownership of the assignor, they would be the person entitled. I think you have to say that the effect of the deed of assignment we looked at is that both the right to receive the money and ownership of the shows in action passed by way of that equitable assignment.
Yes.
Do you accept that's the challenge that faces you?
Well, I mean, I say it's not a challenge because the equitable ownership.
No. I'm sorry.
Together with.
Sorry, let me put it this way: is that the question?
Yeah.
You say
Yes,
you
that's a
can
fair
rise
way-
to the challenge.
Fair way of putting it, but it's not simply the equitable ownership. I do rely on the fact that the passing of the equitable ownership, together with the irrevocable payment direction, was sufficient to pass the right to the income to Scion Bank.
Okay.
And Scion Bank thereafter making a further arrangement with the money that it had received is something different.
But would you? I mean, do you accept that if what Scion Bank had simply was the recipient of the money, but was not the owner of, in any way, shape, or form
Oh yeah,
of the
yeah,
receivable, then you're
yeah.
through.
Absolutely, totally accept that receipt and entitlement are different concepts, and that if Scion Bank was not entitled to the money,
The shows.
entitled to the income. It is the effect of the assignment of the shows together with the payment directions that will provide the answer to who has got the entitlement to the income.
So you say the only people that were entitled, well, you say the bank was both the recipient and entitled.
Yes, there was no mismatch between receipt.
There's not one of those cases
and
where there's
entitlement.
a discordance between who's received and who's entitled.
And very, very deliberately so. that the security that they wanted was of the strongest possible kind, so that the individual traders never had any real entitlement to the income. It all had to. This the 1.7.
It was part of the churn, wasn't it? Going back to your flow chart.
In Mr. Good's case, it was £1.7 million. All the others together, huge amounts of loan money, huge amounts of interest, all kept absolutely sewn up in the Scion structure, and not in any circumstances being allowed to be paid out in any way. Had no sort of control over this. Control is not the right test, but in terms of who in reality was entitled to this money, it was all kept within Scion, very, very deliberately.
Just remind me, and it may not make any difference, but do I recollect seeing in one of the documents that in fact they could have chosen another means of payment of the interest? In other words, it didn't have to be part of the churn. They could have brought in money of their own from the outside.
When you say they, that
sorry, they, the investor.
In theory, yes.
Yes,
Yeah.
I mean, I think that was provided for in one of the documents,
Yes.
wasn't it?
Yeah. But really, what you've got to do with all these arrangements is sort of judgment as to how they were intended to operate. It's Lord Hodge in the Rangers case. So to pick up my Lord's point on this distinction between receipt and entitlement, and which qualifies, again, that's picked up by Lady Justice Andrews at paragraph 15. So it's clear that either receipt of or entitlement to the distribution will suffice to make an individual liable to pay tax on it. One of the issues arising in the present case is whether those concepts carries with it by necessary implication require an element of control over the money or real benefit from its receipt. Mr. Khan's argument being, well, yes, I may have been the shareholder, I may have been the person who was entitled to it, but it didn't benefit me because I had a corresponding obligation to pay it on to the vendors, and that was the argument that was rejected. And so what we say about that is that when one's looking at the position of Scion Bank and one's looking at who had the entitlement to the income as it arises, well, we go through the process that my lord has suggested. But once if you worked out that under this contract it was Scion Bank who was the person with the real receipt and entitlement, then you don't further say, well, wasn't really, because Scion Bank was didn't receive a real benefit from it because it had promised to Mr. Good to discharge his obligation, because that's a separate matter looking at the overall benefit. Although in the end, you would say that Scion Bank had the benefit of the money because discharging Mr. Good's obligation in that way was the way it ensured that it got paid, and it didn't go to Mr. Good who defaulted on the loan. There was a timing element in Khan, in that the actual cash that Mr. Khan had used to pay the vendors had been taken out by way of a loan from the company, which the company then set off by doing the distribution. But the timing was important to work out who had the entitlement at the time the distribution was made. But that was the only reason for it. So that's the sequence of events set out at 19 to 20. We have Mr. Khan buying, paragraph 19 at F, Mr. Khan buys the shares from the shareholders for 1.95 million in cash, plus an amount equal to the net book value, and then less than 40 minutes later the company bought back from Mr. Khan 98 of those shares for cash consideration of 1.95 million, leaving him with one share. The share sale and buyback transactions were documented respectively in the share purchase agreement and an off-market purchase agreement, each of which completed on the 28th of June 2013. So the steps were step 1, approving the transfer of shares; step 2, the share purchase agreement being executed; step 3, Mr. Khan then, as director of the company, approved the purchase agreement, which is the share buyback, which gave rise to the distribution. And the point about the loan was made at 24 on page 529, saying that the upper tribunal found at paragraph 92 that the payment of the 1.95 million by the company to Mr. Khan was a loan to enable him to acquire the shares from the vendor shareholders under the SBA. Although the loan was not documented as such, it was the only way in which the payment could be characterised. It wasn't as a gift. His obligation to repay that loan was then set off against the company's obligation to pay Mr. Khan 1.95 million as the price of the 98 shares it was purchasing from under the off-market purchase agreement. It's common ground that the payment made by the company to Mr. Khan on the purchase of its own shares was a distribution, chargeable to income tax under Section 383. Mr. Khan, unfortunately, it's not permissible to deduct the capital acquisition cost of the shares. Then over the page, this is where they stress that the precise timing at 26, although the cash flow was all in one direction, there was only one cash transfer made by the company. It is of importance to note that it was not the earlier advance, but rather the payment of the purchase price for the 98 shares by the company, affected by that set-off that constituted the taxable distribution by the company under the buyback arrangement. The company had no legal obligation to purchase the 98 shares until Mr. Khan executed the buyback, the final sequence in the steps. At the time of the transfer of the 1.95 million, Mr. Khan wasn't a shareholder in the company, nor a trustee of the shares. He was therefore neither legally or beneficially entitled to distribution out of the company's assets in respect of those shares. In any event, the parties are bound by the upper tribunal's finding that the transfer was not made under or pursuant to the purchase agreement by the time of the implementation of the off-market purchase agreement, i.e. the buyback, less than 40 minutes later, by which time the money had already left Mr. Khan's bank account. That situation had changed, and he was the legal and beneficial owner of the entire issued shared capital in the company, and the only person entitled to such a distribution. On that finding, you might think, well, that should be the end of it, but Mr. Khan's argument was that it was appropriate to look at this as a single transaction, and therefore look to see, well, did Mr. Khan actually get any benefit out of this, or should you also take account of the contractual obligation, pre-existing contractual obligation he had, sort of to pay the money away. That's Mr. Khan's case at 39. It's really the essence of Mr. Khan's argument. At 39 on page 532. Mr. Sykes for Mr. Khan had submitted that the upper tribunal erred in law in refusing to consider the sale and buyback of the shares as a single composite transaction and consider its overall effect, rather than concentrating on the machinery by which it was affected, i.e. the legal steps in the chain. In substance and truth, Mr. Khan was no more than a conduit for selling the shareholders to effect the buyback of the 98 shares themselves, and his intermediate role in that aspect of the transaction should be ignored. As a matter of practical reality, the 98 shares were never Mr. Khan's to do with what he pleased, nor were the buyback proceeds. What was saying that you, in a case like this, you shouldn't be looking at the various legal steps in the chain, but you stand back and say, well, was there some benefit or control provided to someone other than the recipient of the shares, and that would really be the key factor. So in the present case, the legal steps in the chain are the payment of the income to Scion Bank, that's step one, and then step two is the discharge, the application of that income by Scion Bank to discharge Mr. Good's obligations. And so we would say, well, you don't take a composite view of that and say, well, it ended up by satisfying Mr. Good's obligations, so he must be treated as the person who's receiving or entitled to it under this. The different steps have got to be given their own significance. So at 41, a similar point is made, nor did it matter that Mr. Khan acquired and kept the 99th share for himself, and thereby obtained ownership of and control over the company. It's important not to confuse the question whether he benefited from the transaction as a whole with the question whether he benefited from the buyback proceeds. So here, again, the question we've got to focus in on, as the court will say, is what happens, who was entitled to the distribution, to the payment of the minimum annual payment, of the fact that it was thereafter used to discharge an obligation shouldn't matter. So in light of that argument, the discussion on receipt or entitlement takes place at paragraph 49 thereafter. Lady Justice Andrews begins with a case on sort of composite transactions and looking at how one treats sort of composite transactions in tax purposes, and picks up a statement from Lord Reed in the UBS case, which makes this a sort of important distinction about, well, whether you're looking at something as a composite transaction or not really depends on the statutory phrase that you're looking at. And at 50, the statement is that it might be said that transactions must always be viewed realistically if the alternative is to view them unrealistically. The point is that the facts must be analysed in light of the statutory provision being applied. If a fact is of no relevance to the application of statute, then it can be disregarded. If, as in Ramsey, the relevant fact is the overall economic outcome of a series of commercially linked transactions, then that is the fact that is necessary to focus. If, on the other hand, the legislation requires the court to focus on a specific transaction, as in McNiven and Barclays Mercantile, then other transactions, although related, are unlikely to have any bearing on its application. So the starting point was sort of against Mr. Khan's argument that you do actually look at it at each step in the chain, in particular when you're looking at the concept of receipt or entitlement, and the fact that if at step one of the chain there is receipt and entitlement in the hands of one party, then the fact that a benefit is provided to another party at step two of the chain is irrelevant. They then give a warning, and gives a warning at the top of page 535 against the dangers of trying to import interpretations of similar words or phrases used in the context of other statutes, which have entirely different purposes. And particularly when we come to look at the beneficial ownership, mere legal shell type cases, that is something that the court views as coming from really, it's a different statutory regime. So that's why I say they didn't actually adopt that at all. So at 52, they just says, in my judgment, this is a case in which the legal nature of the transaction to which a tax consequence is attached does not emerge from looking at the connected transactions as a whole. On the contrary, statutory provisions require the focus to be on the transaction under which the taxable distribution arose. And at 53, the upper tribunal undoubtedly started in the right place by seeking to ascertain the purpose of the relevant statutory provisions, give them a purposive construction. Cites ought to challenge that construction on the basis that the upper tribunal had erred in finding that paragraph 54 that section 385 uses entitlement as a way of, as a result of the way in which tax credits in respect of the distributions previously operated under the old regime. So that was the upper tribunal's use of the explanatory notes, but the Court of Appeal saying no, the upper tribunal was entitled to take that into account. And 54, they agree with the upper tribunal that irrespective of actual receipt, the person entitled to the distribution is the person to whom the distribution belongs. So that's their sort of starting point. And they then looked at cases where the courts had considered the word entitlement in other statutory contexts. At 55, these were relied on by Mr. Khan. But was saying you didn't really get much guidance from cases looking at other statutory contexts. They don't help to look at the concept of entitlement under Itoya, and so conclude at 57 that section 385 is concerned with the person who actually received the distribution from the company, and if different, the person to whom that distribution belongs. In this case, they were one and the same. And so in the present case, we would also say that it's one and the same, Scion Bank. Then they turn to the question of control, but that was really in the context of whether it could be said that Mr. Khan had received it. For Mr. Khan, there was a double problem because he had actually received it, and they found he was entitled to it. So to try and get away from that, Mr. Khan needed to argue that control was an element, and because Mr. Khan had sort of fettered his control because he'd already contractually agreed to pass it on, he couldn't be treated as having received it. But that argument was rejected because receipt and control are different concepts. Then they turn to the concept of entitlement and benefit at 64. And they begin by looking at the noting that Mr. Khan had placed considerable weight on Bupa, which is one of the wood preservation and prior cases. The only difference in Bupa, it was a similar type of case of corporate groups. The only difference from wood preservation and prior was that the concept of common ownership was defined by reference to the concept of beneficial entitlement to distribution. So wood preservation and power was looking at just simple beneficial ownership of the shares. A slightly different way of finding out how the interest arose in the Bupa legislation, which was a beneficial entitlement to the profits. So it's more to do with beneficial entitlement to the underlying income. But again, they didn't think that that type of analysis was particularly helpful because all those cases, looking at wood preservation and prior and Bupa, were dealing with a slightly different issue. At 67, the question that was being addressed in Bupa was not to whom the distribution belonged. The distribution plainly did belong to the company in the Bupa case, because it was the legal and equitable owner of the shares. So they say that the Scottish Provident case on entitlement isn't really relevant for this purpose. They're saying that these other cases on beneficial ownership within the group context are not particularly relevant for this purposes. And then they looked at wood preservation from prior case at paragraph 67, and note that for that purpose ownership had to be something more than a mere legal shell. And so they then conclude their analysis on Bupa and wood preservation and prior. Essentially, those cases establish, it's at the bottom of 539, even in a statutory context in which equitable ownership may not be enough to amount to beneficial ownership or beneficial entitlement. The focus is on identifying the person who in reality has the right to the money. Any legal obligation they may have to treat that money in a particular way after that right accrues or after payment is made is irrelevant. So in the present case, the upper tribunal made particular emphasis on the fact that under the steps that were taking place in the present transaction, that Scion Bank had agreed to discharge Mr. Good's interest obligation. It had entered into the undertaking to make that discharge as part of the payment directions, but it was clear from the way that they agreed, it was intended that Scion Bank would be the person receiving it, and after the payment was made, it was the person who then subsequently promised to Mr. Good to discharge his obligation. So the two steps are relevant. So the upper tribunal's approach, saying, well, you've got to look at the fact that Scion Bank didn't simply get the money, it promised to make the discharge of the obligation. Therefore, that was a benefit to Mr. Good. Therefore, he should be the person that's really treated as entitled to the money, is inconsistent with this reasoning here. Because it's quite clear that any legal obligation that Scion Bank had to treat the money in a particular way after its right accrued or after the payment was made is irrelevant. And then broadly they say that none of those Bupa or wood preservation cases comes anywhere near establishing that in circumstances where the only person who is or could be legally and beneficially entitled to distribution at the time when it is made is contractually obliged to pay an equivalent amount to someone else and uses the distribution to discharge that obligation. He is not entitled to the distribution, he does not receive the distribution, or his entitlement to receipt of the distribution is to be disregarded. So again, those cases are far removed. But the key point they're making here is that you've got to look at it at the time, at the step where the payment is made, and if someone's received or entitled to it at that stage, then the fact that they have promised already to pass it on so that it benefits another person is irrelevant. So that might be a convenient moment.
Yes, I think so,
pause.
because presumably you're going on to composite transaction.
Yes, exactly.
Yes, 2 o'clock, please.
Court's raised.